The British Virgin Islands is one of the world's leading international financial centres and is well known for its flexible commercial legislation and English-based legal system. BVI companies feature prominently in all types of financing structures across many different sectors with investors located throughout the world. Here are the 10 essential things you should know about financing transactions involving BVI companies. BVI companies are required to have a registered agent in the BVI at all times. The registered agent maintains or holds copies of the company's register of members, register of directors, and register of charges and its minute book. The agent provides the company's registered office and acts as a liaison between the company and the BVI Registry of Corporate Affairs. Details of the directors and shareholders of a BVI company are not publicly available. The registered agent will need to provide a registered agent certificate or certificate of incumbency to confirm this information. Provision of a registered agent certificate in respect of each BVI obligor should therefore be included as a condition precedent and will be required in order for a BVI legal opinion to be obtained. Conditions precedent for obligors incorporated in the BVI should include director resolutions and, if necessary, shareholder resolutions, director certificates that certify the copy documents delivered, registered agent certificates, and certificates of good standing. Certificates of good standing can be obtained from the BVI registrar, or by the company's registered agent, or BVI legal counsel within 1 to 2 business days. A BVI company will be struck off the register of companies if it fails to maintain a registered agent in the BVI or fails to pay its annual government fees to the BVI registrar. A company that has been struck off can no longer carry on business, deal with its assets, or be a party to legal proceedings. Where a company has been struck off for non-payment of its annual fees, it can be restored to good standing very simply by payment of all outstanding fees and penalties. If a company is struck off for a continuous period of 7 years, it will be dissolved and a court application will be required in order to restore the company. There are no required formalities or perfection requirements in respect of charges over the assets of BVI companies. Charges over assets of a BVI company should, however, be entered on the company's private register of charges. Although not mandatory, charges may also be publicly registered with the BVI registrar. This is a good idea in order to secure the priority of the security, as charges that are publicly registered take priority over those that are not so registered. A sale, transfer, lease, exchange or other disposition of more than 50% in value of the assets of a BVI company must be approved by both its directors and shareholders. This statutory requirement does not apply to dispositions made in the ordinary course of the company's business, in respect of the granting of a mortgage, charge or other encumbrance or the enforcement thereof, or if it is specifically disapplied by the company's articles of association. BVI companies are not subject to income tax, VAT, stamp duty, or any other taxes in the BVI, nor are they subject to any registration or transfer fees or charges in the BVI in connection with the execution, delivery, or performance of the transaction documents, apart from filing fees for the public registration of security. The official currency of the BVI is the US dollar, and there are no exchange controls under BVI law. Financial assistance restrictions or guarantee limitations do not apply to BVI companies, which have clear statutory power and capacity to grant guarantees regardless of corporate benefit. Where a BVI company is a wholly owned subsidiary, the company's memorandum and articles may also provide that the directors may act in the best interests of the parent, even where that action may not be in the best interest of the company itself. The directors of BVI companies may declare distributions if the relevant solvency test is met. For companies incorporated under the BVI Business Companies Act, the test is that the value of the company's assets exceed its liabilities, and the company is able to pay its debts as they fall due. Failure to satisfy the relevant solvency test may result in recovery of any funds from the relevant member, but does not affect the validity of the distribution itself. The term distribution is widely defined under the BVI Business Companies Act and includes incurring a debt for the benefit of a member. Guarantees granted in favour of a parent company may therefore fall within this definition. In light of this, it's important that the directors of BVI companies consider the relevant solvency test when granting upstream guarantees, and specifically set this out in the director resolutions approving the granting of the guarantee. The BVI courts will recognise as a valid judgment a final and conclusive judgment from a foreign court against a BVI company under which a sum of money is payable, other than in respect of multiple damages, taxes, fines or penalties. Subject to certain restrictions, awards granted pursuant to foreign arbitration proceedings against BVI companies are enforceable in the courts of the BVI either by action or by leave of the court. Where leave is given, judgment may be entered in the terms of the award. At Conyers, we regularly act on behalf of lenders and obligors on a wide range of financing transactions, including project and acquisition finance, structured finance, and asset finance transactions. Our experienced finance team can provide expert British Virgin Islands law advice. Contact Conyers today.